promised, or was it threatened, that we would have a Q&A and comments from you today, Monday, the first day we're going to do this, try and do it on a weekly basis, and just kind of chat about the cases that are in the front part of your brain. I can't imagine what we might be talking about today, Linda. Any particular thought about a case that anything come to mind? Here, let me. This will be a
little. Wait, what is?
Maybe I can help. Maybe help jog your memory. When the judge puts on gloves and jumps off the bench and starts looking at evidence, as was done in the Alec Baldwin former trial, something's up. Something weird is happening.
Wait, put your gloves there.
I have the blue. My only glove I've got is this. Oh, okay. All right. You have the high-end version of the glove. So what was your first thought? Let's start there. We're going to start with Baldwin, and then we're going to get to these questions.
Absolutely right. A judge who finally had some sneakers, who was really pissed, Michael. I don't know if you saw her cut off the prosecutor when she learned that the prosecutor, in this case, the special prosecutor who had tried the previous case, against the armorer, Hannah Gutierrez, found out in the Baldwin case that live rounds of ammunition came in, and she made the decision, along with the apparently the lead detective or a lead detective, to put the evidence rounds under a different number, so they were hidden from the Rust people and they weren't considered rounds in the Rust people. Then try to intimate that indeed the defense had a chance to look at those rounds when they had the evidence viewing, when they weren't even under the Rust number when they came in for chain of custody, and then suggested when she got on the stand herself to testify that the reason why her assistant prosecutor, co-prosecutor who gave the opening had left the case was because she didn't want a public hearing, when it was because she thought the case should be dismissed because there had been misconduct, and she wasn't going.
And she was embarrassed to be connected to it. Of course.
Yeah.
Okay. So, I will just say before we get into these, that we're going to hit all these topics. There are a lot of questions that have to do with procedure versus the substance and the merits of the action. Very different issues. And when I left the Air Law and Crime on Friday, they had just begun to lay out this testimony. And, the brilliant brains in the studio at that time thought, the prosecutor's going to get a slap on the wrist. They're going to get some sort of admonition to the jury. Nobody really thought this was going to happen. And this is due to the brilliance of the defense team by laying this trap for the prosecution. They could have brought this motion about the hidden evidence long before trial, at the moment they learned of it. But by waiting till the jury was sworn in, the trial had begun, double jeopardy attaches, and it takes any other remedy off the table. You got to just dismiss the case. So brilliant. Anyway, so let's jump into the questions here. One of the first ones here is what impact, and this comes from Logan M. What impact, if any, will this mistrial have on any civil litigation that Alec Baldwin may be facing? Can anything from this be used for or against him? That's a good question.
It's a great question. And the answer is no. The civil case is going to be different. Whatever he did in the civil case, remember the standard of proof, the burden of proof in a criminal case is beyond a reasonable doubt. And in a civil case, it's just a little over half. It could be 50.0999%, right? And so it's just different issues in liability. And in the civil case, they may assume that he has producer liability. They try to prove it. But hiding the evidence will not impact the going forward of the civil case.
Here's what it does do negatively. Sorry, Gloria Allred. If you have a civil case that is trailing a criminal case and you get a criminal conviction, you're done on the civil side because of the burden of proof being beyond a reasonable doubt, preponderance of the evidence. This trumps, I don't know why I use that word, this trumps the civil case. And so therefore, you're done. I mean, it's really, you don't have to really do anything. Well, now Gloria Allred in her civil cases will have to do what they normally do, which is either prevail prior to trial or at trial by a preponderance of the evidence. And these are, wrongful death type actions. So
settle the case with the insurance
company. Or, of course, which is what most of them do. Okay, next question here. This is this is kind of the procedural versus the merits of the case question, because people are saying, well, from what I understand, the bullets weren't really part of what happened that day, and besides, Alec Baldwin didn't put the bullets in the gun. It's what he did that day, and I understand that confusion. So the question, from Cranial DC. Cranial DC. Why would bullets not likely to even have been at the New Mexico movie set even matter, let alone lead to dismissal?
Because you don't know what the impact is and what the defense could have done with them had they known about this evidence before trial when they did the inspection. And as a matter of fact, the prosecutor said that was her argument. They didn't match anything. But then the judge said, I want to see them. And she pulls out, where's your glove? Where's your glove? She gets off the stand, not to sit at the defense, not to sit at the prosecutor bench, to actually sit. She said, I want to see the evidence. And she pulls out 3 rounds that appeared to actually match the rounds that were in Baldwin's gun, showing that perhaps there was real terrible negligence on behalf of somebody else, not on behalf of him. That people knew maybe that there was live ammunition and didn't tell him at all. So you don't know the impact of hidden evidence, and that's the problem.
And importantly, and I did say this on the air Friday, how quickly would cases go if it was just up to the prosecutor to decide what was and wasn't relevant? Because
Right.
this prosecutor, Morrissey, basically said, there wasn't the same ammo. It never made it to New Mexico. It's irrelevant. Well, thank you, God, for deciding that for the defense. You can't do that.
Yeah, and as
You
a
just
matter of
can't.
fact, there are some prosecutors' office like LA who have a Brady committee of sorts, and they go in and decide whether something should be turned over or not. And defense lawyers argue all the time, wait a second, the prosecutor can't tell us whether it's important. The defense needs to know about it, however minuscule, to see whether it may be important. So a lot of those times when they say, well, our Brady committee looked at it and they didn't think it's relevant, that is garbage.
And the bottom line is the process is so much more important than one case. I don't know, and we'll never know if part of the judge's um, evaluation was, look, case was not very strong anyway. We knew he wasn't going to be attacked as a producer, which I thought was the strongest argument for Alec Baldwin's culpability. That's out because the prosecutor failed to properly indict in the grand jury on that specific role. Maybe the judge thought there was less harm in this particular case, but I think her overarching message was, don't screw around. Don't screw around with the rules because we're going to slap you down, and this is a fatal remedy.
Right. And
Lucy,
by the
I
way,
think I have one more.
when we talk about Brady, let's make it clear to our audience that Brady is a case an old case in the U.S. Supreme Court that says you have to turn over evidence that may be exculpatory to the defense. And that's simply what basically everyone follows.
Yeah, and it ain't up to either party to decide what is or isn't relevant. So,
right.
Let's see. This is interesting. JB123. What is going to happen to Prosecutor Morrissey? What are your thoughts on that?
All right. I predict, and I actually tweeted about this, that she's going to have bar discipline and that she may even lose her law license. Okay. Depends on what her history is in the past. The problem you have, and this is why I think she could even lose her law license, is there's another case, the one we talked about, the armorer, who I do think is at fault generally in terms of an involuntary manslaughter. But if there was evidence hidden here, what evidence was hidden there? What do we know? What's the effect on it? And if she knew about this in 2 cases, she has subverted the justice system. It may have to be reversed and maybe retried or not retried. And you have all these, you do have victims here. You have people who were shot who really can't get any justice. And maybe the person they're seeking justice from hasn't even been brought to trial because maybe, I hate to mention the word conspiracy again, but is an interesting thing as to why these rounds got in this gun. Was it mere negligence of the armor or was something else going on that set?
And it really just muddies the water for the case already tried. Morrissey on the stand made it sound like, hey, I wish I had known about this evidence because it would make my case stronger against Hannah Gutierrez Reed. Again, an unknown that didn't seem to come into play in that trial because they suppressed it and decided it wasn't important.
I don't want to talk over you, but more importantly, because I know we've had comments about that. The judge thinks that she lied on the stand because she asked her specifically, and then when she wouldn't answer from Alex Spiro, the judge took over. that the crime scene, Popolo was it, investigator who was responsible for this,
Popple, yeah.
said you were in the meeting and you're the one who told us to put the bullets under a different number, not related to Russ. So I think the judge thinks she lied on the stand. We'll never know if the judge refers to the bar, but the judge does the referral to the Bar Association. We're going to be on the beach in Curacao for a long time.
It's it's one of those situations where the court has to be looking at it from a 30,000 foot view. They can't just look at the intricacies of a given case. What's the broader implications of what was done here? And it was bad. It just stunk. And just because Morrissey made the decision she did doesn't mean it's going to help either of the other cases, and that's almost irrelevant. It's what she did and how she did it. And I'll say to your point about talking over one another, because we're going to transition now to the Karen Read case, which is still a hot topic. We listen. We are very passionate about our positions and about these cases we talk about. So we've been known to kind of compete with one another. We're working very hard not to do that anymore.
It's like
Okay.
it's kind of
So-
like a relationship, isn't it, or a marriage? We're working very hard not to talk.
We are.
Sometimes well, I won't even say it. I'll just zip right now.
We're in therapy. That's what you're trying to say. We're in couples therapy. Okay, so hold on a second. Let me pick one here. Oh, this was a great one. No, that's the wrong one. Sorry. Let me catch up. Oh, let me mention the law first very quickly. As we used to say in law school, we'd get a fact pattern of some sort by the professor. The first question, really was, what's the law? So what's happening here. So I wanted to learn as much as I could about the jury verdict issues. As we know, in the Karen Read case, there have been now 4 jurors that have come forward, allegedly through affidavits of Alan Jackson and co-defense counsel, suggesting that, hey, we already came to a unanimous not guilty decision, counts 1 and counts 3. That was never documented, apparently. The question then becomes, what happens? What are the options? So I was looking at the federal rule of criminal procedure, Rule 31, which deals with jury verdicts, right? And then I wanted to see if they applied that to Massachusetts. If they, a lot of states just copy the federal rules. So bear with me as I read this. It's not a lecture in law school, but you'll see the important parts here. If there are 2 or more offenses, the jury may, with the consent of the judge, at any time during the deliberations, return or be required by the judge to return a verdict or verdicts with respect to charges as to which a verdict has been reached. Okay, separating them out. Therefore, the jury may, in the discretion of the judge, resume deliberations on those other charges. The judge may declare a mistrial at any time on any charges that they cannot agree upon, provided that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. It puts it all on the judge. One more thought. In the notes relating to that rule, and that's rule, by the way, if you're taking notes here, that's Rule 27, Massachusetts Rules of Criminal Procedure. The right to find out about the jury and where they are in the process is no longer a right for the defendant. They had some case law that changed that. Polling of the jury is to be discretionary with the court rather than a right of the defendant. So we've talked a lot about how, well, why didn't the defense, demand a polling? They could request it. They didn't. They could. They didn't, and the judge didn't do it on her own.
But also, as I said in the past, the judge usually comes back when someone says they can't reach a verdict and says, well, is there any charge? Do you have any charge that you can reach a verdict or have reached a verdict on? Or in the original instructions, in many states, they'll tell them if you reach a verdict on any one charge, but you're hung on the others. Usually this happens later, though. You can come back and tell us she never asked that. She didn't. Yeah. She didn't ask that. And the slip, which is the verdict sheet, as we call in most places, including in federal court, was very confusing. We've been through that. So now you have 2 jurors, I understand, that have called Alan Jackson's office directly to say that they have reached a verdict. So I'm sure there's something going on behind the scenes. But Michael, can I ask you a question? I think there's a relationship here between Baldwin and Read. And it begins with B, Brady, the case we talked about. because we now know that your Proctor Factor fellow, Mr. Proctor, former well, he is a state trooper, the lead investigator for this case all the way through trial, has now been removed. He is now doesn't have any pay. He's been sent somewhere, I don't know, out of Siberia. Uh, if there were discussions that were hidden from the defense, that they planned to do this after trial because they just tried to keep him there, not disciplining him because they wanted him to look good. Is that Brady?
I know you've brought this up before, and I think it's a unique attempt to use Brady. I'd have to do some serious research because off the top of my head, it doesn't scream Brady, but it smells like Brady. And so I think I don't know. I'd love to see the case law to see how that application has been applied in the past. I've just not seen it.
Yeah, and I'd love to see some
So
of our viewers who are great researchers research it, because boy, does that stink of it does stink of Brady. And again, if
mhm.
there's hidden material, it's really interesting. I thought that in the Karen Read case, after Baldwin, after we're looking comparing them, remember you had, and you were the one who brought this up. I think you were even on the air. That the video of the car, the SUV, was it reversed, was inverted, right? And so there were all these questions. Did you touch it? Did you touch it? Did you touch it? They said, no, no, no. And then it turns out that the Yuri, I can't remember his last name, who I thought initially was a great witness. And then afterwards, I thought he was basically a liar on the stand, but that was just my opinion. Um, they all said no, they hadn't touched that right rear tail light. And then it turns out that the video was inverted and they all had been near it or touched it in some way. You couldn't really tell because of the 3D versus 2D. And I thought that was basically a lie. Why didn't the judge dismiss the case based on that, since that was withheld evidence?
Well, I know that there wasn't a specific motion that they do that. I don't remember anything addressing it specifically. They certainly used it as major cross-exam fodder, but I didn't hear any defense motion to dismiss as a result. So, as
Maybe
it
that's the
turns out,
difference.
yeah, it could be. Okay, so here let's look at some of these questions in the Karen Read matter. Um, I'm still. This is from Karen Peck, 54. There are 53 Karen Pecks apparently ahead of Karen Peck, 54. I'm still not clear. Did the jury fill out not guilty on number one and number three, or was the whole form left blank? Now, I've done a little research, and I don't see anywhere that that was made public. So we're speculating as to whether or not it was filled out or not. My guess is, and I mentioned this in some response to some of these comments, giving the judge the benefit of the doubt, I can't believe she would totally ignore a verdict slip that had not guilty marked on one and three. Remember that those options were there. That wasn't the issue that was brought up during trial where they didn't have not guilty for the lesser included. This was the top charges, the top main charges. They did have a not guilty option. So what do you think? Is the judge going to ignore that if it's marked?
Well, no, the judge isn't going to ignore that if it's marked. And it sounds like what the jury was doing was thinking that they had to, they had to go through the list. And if they were hung on all of them, you just didn't fill out the not guilty on the top, that they had reached that. And it was very, again, unclear from the charges. If you don't find her guilty on the top charge, do you go to the rest? Or tell us if you find her not guilty on the top charge. And it comes back to this slip, and it comes back, quite frankly, to the judge refusing initially. Remember, she wouldn't initially even put a not guilty on the lower charges, if you recall. She was standing her ground, right? And I think that is what's caused all the problems in this case. And I agree with you, Michael. I don't think she could ignore a not guilty on the top charges.
Yeah. Yeah. And so, most better written forms, I called it a verdict form. I'm not going to go with the verdict slip. You would have an if then kind of, like a flow chart. If, not guilty, then, sign and move on or whatever. But it gives them very clear direction, because when the form doesn't give them direction and the judge doesn't give them direction, they're just, they're lost. And in this case, it's caused a real issue because, again, according to these juror secondhand affidavits, they did come to a decision on one and three, which were the critical counts. Okay, let's see. How can Karen Read be charged? This is from Blipco 5. How can Karen Read be charged with leaving the scene when she didn't hit John O'Keefe, J.O., and wasn't there when he was murdered? Well, it kind of takes a lot of things and assumes them based on maybe somebody else's perception of the evidence. I don't know if you can concretely say she didn't hit him and wasn't there when he was, this person says, murdered, died. I don't know that any of that is clear. What do you think?
Well, one of the things was that I think the jurors, at least in what I'm reading about these other affidavits and why they were hung, some of them believe that she didn't hit him, okay, at all. So that's one issue that they believe. So then how did he die? Did he die because he was drunk and fell in the snow and fell backwards and cracked his head? And then he died of hypothermia with that? Or does this, do some people believe, like our viewer here believes, we asked the question, obviously, that there was a murder and a cover-up, or a homicide and a cover-up. I can't say murder because I don't think anyone would intentionally go out and kill him, but the argument was they had a fight. He died accidentally in the fight, and the dog was involved somehow in the fight with those scratch marks. Remember those scratch marks up here? And then he was carried outside and left in the snow, and that's what led to the alleged search, Google, on one of these iPhones that said, how long has to die in the snow or something like that at 2 o'clock,
Yes.
as opposed to 6 o'clock. I don't know if that answers your question, but follow up if we are not answering your questions.
That's a good idea, because I think we filled in some of the blanks, but maybe didn't get to the ultimate question or answer, because there are some either or propositions there. Okay. I also like looking at the comments too, not just some of the questions. This one, obviously, a deranged person. Mrs. Bodden is always correct. Full stop. So glad I found you all. Thanks for your insight.
Wait, what's her name? Okay.
Yeah. You want to send her the check you promised? It's Tuit Thomas, I think is what it is. Tuit Thomas 4560.
I think I love Tuit Thomas 4560. Thank you very much.
Okay. So moving on here. This is from Norm Thompson. Oh, not Thomas. Thompson 923. No gun, no evidence. Oh, wait, this is the wrong case. Sorry, wrong one. I'm trying to get my notes ordered up here. Let's see. Okay. Behind all of this is again referencing the ballot, the verdict slip. Behind all of this, the court has a signed jury ballot sheet that proves there was a hung jury on all charges, or the court failed to do that job as a referee to the two sides. Should Jackson be sanctioned, or Bev, the judge, get fired?
Oh, really interesting. Well, Jackson can't be sanctioned by the court for not maybe following up. If there is anyone who would complain, it would be his client, Karen Read, and I really don't think she's going to complain. And the reason is this case, especially if Judge Bev, as you call her, doesn't give a remedy to find out what the verdict actually was, is going on appeal forevermore. And Karen Read is never going to be tried for the murder of John O'Keefe. Again, they may try, but even if there was a conviction, it's going out the roof, in my opinion. Goodbye, so long, very well. Will Judge Bev be sanctioned? No, that won't happen. Judges are terrible all the time, make mistakes all the time, and nothing happens to them. There's judges who have wrongful convictions in their court, let in wrong evidence in their court. People spend 30, 40 years in the court, and the judge is out playing golf somewhere.
That's not a bad idea.
Wrong thing, golf, I know.
Yeah. So I would hope, I'm kind of Pollyanna-ish, I would hope that somebody somewhere learns from this and they make some sort of change to either the way the verdict slip is created, or the judge's interaction with the jury when a situation like this comes along again. And it will. It may not be in as high profile a case, but it's going to happen. There's nothing new under the sun. It will happen. Okay, let's see. I think we got one more here. I'm going to have to get much better organized. Oh, here's a nice comment.
I'm in couples therapy with you. I can't comment anymore.
I like this one here. It says, "I'm sorry, what was that? Linda was talking." No. Okay. Okay, and then just kind of an outrage comment and question. Acquitted? She wasn't acquitted of any charge. And I think that suggestion is that it's too late for whatever the jury did or didn't do to really matter. So is it too late?
No, it's not too late if the judge has a process and procedure to call the jury in to find out if there was a verdict on counts 1 and 3. The question is the judge going to use it? And then the question comes, if she doesn't use it, is it going on appeal? Then the question comes, does it go to the Massachusetts Supreme Court? And then doesn't go to the U.S. Supreme Court on the issue of due process, because that's really what it comes down to, right? So we got a long way to go. Maybe she wasn't acquitted. Maybe she was acquitted. That's the problem. We don't know, do we?
That's true. And that's what I think is most interesting about it. And one more. I do have one more here. This is from Rebecca K. I'm wondering, is there anything the defense can say to the judge in the Karen Read case to get a jury hearing? I think what she means is a hearing on these issues we're talking about. Any compelling arguments they could make. So it seems to me that they're going to make a request. They've done that. So now the question is whether the judge will hear it or it immediately gets taken up. I know your position is she's going to just stand on her process, that she did nothing wrong, let the appellate court deal with it. Am I right about that?
Right. I think that's the case, except there's one little matter. There's something called the media, right? You already have 2 jurors, right? And I know from my case, Aaron Hernandez, by the way, with both of these lawyers we've talked about, I've tried cases either against them or had them involved in the case I was with, both Alec Baldwin and Alex Spiro. It's pronounced Spiro, not Spiro. All right. Funny, the Alec Baldwin case, and certainly with Alan Jackson in the Karen Read case. But there's one little glitch. Michael, the media. What if the media has all 12 jurors and they go on the air and they say we acquitted her? What does the judge do then?
Yeah, and I think I think we're 1 step, maybe 2 steps away from that, because these affidavits have not been submitted by the jurors personally. So as I mentioned before, there are big evidentiary problems when you, as the attorney, say, yes, this juror called me, I confirmed they were on the jury and they said this. That's all hearsay. It's not admissible. It does get the attention of the court. The court may ask maybe if she does anything, maybe to hear from them directly. If they will submit to affidavits, then you're a huge step forward for the defense. If Joe Blow says, yeah, I was on the jury, here's what happened, here's my sworn affidavit, far better than what they've got now. So we're going to have to see as it moves forward if anything happens at the trial court level, or as you suggest, it's going to be rubber stamped there and moved up to the appellate court.
And if you are a juror on the Karen Read case, we here at Justice Serve would love to hear from you. Absolutely. We'll give you airtime, let you tell your story directly to people, and maybe that's part of the process. They don't feel they can tell their story directly outwards, or maybe they'll be violating some rule. You're not. You're free to speak. You have a First Amendment right to speak. It's just that no one can come to you and demand that you do speak unless it's the court.
Yep, and I promise I will not talk over you. So if you get a chance, check in with us, and we'd love to hear from you. Okay, that's all the time we've got. Appreciate everybody joining for this live Q&A session. So keep the questions coming. There's always some case to be talked about, and this is a good place to get it off your chest. So we'll see you next time.